If you have a child, you definitely should have a will, and there are a couple of reasons for that. One is it's important to set forth who would be the guardian if something happened to you and your spouse, and there was no one there listed to take care of your child. If you are concerned that that child gets placed with someone who will care and love them as you would do that, it's important to get that in your will. The second reason is if you don't have a will with a trust for your child or children in it, the court will require a guardianship to be established. The court will appoint a guardian to take care of the money for the child as well as the child individually, and the court will then require anything that's spent for that child to go through the court proceedings. So it's one, it takes a lot of time. Two is it can be expensive to go through that process. And three, a lot of times parents might want things spent for the child, but they're not here to tell the court what they want, and the court may or may not approve it. We normally ask our clients to choose a time to review it, sometime between 3 years and 5 years, because circumstances change. You may have named a parent as the personal representative or as a trustee. That parent may have moved out of state. That parent may not want to be involved in those matters anymore. That parent may be 92 and doesn't really want to be involved. So those circumstances change. A will is a document that you execute today, and it's valid today, but it really doesn't come into effect until you're gone. So when you die, then the will comes into effect, and then what you want to have happen with your assets, who's going to be your personal representative, all those things happen at that point. A trust is a document where you can set it up today, sign it today, and it's in existence today. It's essentially you with a hat on or a wrapper around you. So essentially it's your document, you control it, you're the trustee, you place assets into the trust now. So you may put real property into it, accounts into it. And the benefit of having a trust is that if you get incapacitated, your successor trustee can immediately take over and utilize those assets for your benefit. If you pass away, the trustee can immediately come in and take over, and they don't have to go through any probate process to get appointed. So it's a much quicker way of addressing a very difficult time. When someone passes away and they have a will, the first thing you're required to do is file that will with the court and file a petition for administration for probate. And essentially what that means is the personal representative, the person who's named in the will as being in charge of taking care of things. In other states they call them executor or executrix, but we call them personal representatives in Florida. That person asks the court for approval to act. And once that person's appointed, then there's a whole process of what happens next. There's a sequential number of things. Generally takes 6 months at a minimum to probate the assets to get them to where they're supposed to go.